Hi cyber class, it's Professor Opterbeck and this is our weekly update video. Welcome to week 7. As always, I enjoyed reading through the discussion boards. All of you really observed how difficult it is to think about executive power in cyberspace, and as many of you observed, it's hard to think about the limits on executive power at all. The Youngstown framework helps us somewhat, but a number of you talked about how there's lots of cases in the Supreme Court and in lower courts, even wrestling with what part of the framework it might, an action might fall into, and how hard it is very often even to apply that when we have some kind of framework. A framework, by the way, note that it just comes out of a concurrence in a case. It's really technically just dicta, but it's been picked up obviously and applied in later cases. And a number of you talked also about the difficulty of figuring out some kind of statutory way to possibly limit executive power in cyberspace, but to grant the kind of power that might be necessary or appropriate. And again, as we're thinking about these units in our class, whatever your political views might be, definitely the events over the past couple months have showed us the importance of executive power and how sort of precious a thing it is to have limits on executive power. We see that in the US, and we also see that in other countries where they have not been so fortunate in some cases to have institutions that have been able to withstand this kind of problem, and or have had really regimes that maybe quite legitimately needed to be removed, and how difficult that can be. So really interesting discussion, and how this extends into cyberspace makes it even more interesting. This week we're going to be beginning a 2-week discussion of human rights in cyberspace. And we begin talking about in the West, that is basically in the US and in Europe. And you'll see some of the similarities, but also some of the differences between how the US and Europe treat online speech, online rights of assembly, and particularly the problems that are posed by hate speech, by violent content, and by terroristic content. And then next week, when we look at that outside the West, we'll see how some regimes that are really oppressive regimes use the same rhetoric of hate speech and terroristic content to justify really sweeping limits on speech online and on surveillance. So a very interesting dilemma, again, a really tough policy choice. You probably know that a lot of this debate in the US right now centers on Section 230 of the Communications Decency Act. So we'll look at Section 230. I added to the reading a piece of mine, not a law review article, a really more of an opinion piece that I recently published in a publication called The Bulwark. Take a look at that. You don't have to agree with my perspective and my arguments in that piece, but at least I think it'll give you a bit of a feel for where that debate stands in the US. And it's not just terroristic hate speech, violent pornography, things like that. It's also political speech and questions of fairness. It's, President Trump getting banned from Twitter, and how we deal with those kinds of questions raises a whole basket of other issues that we have to think about. So have fun with it, and I will see you online.